Hello, hello, it's me again, the snarky juror. And we are still on the Massachusetts versus Karen Reed trial. We are in the verdict watch right now. And there's a lot of us that are perplexed. And it doesn't seem to be getting any better. We're going to go back. I couldn't go back far enough to find where court first came in session and they released the jury to go to deliberations. Couldn't find that. What I could find was the jury had a question. And I could find, excuse me, let's do, excuse me again. I had garlic and chicken and lemon. And steamed broccoli and baked potato. So excuse my burping. And now I'm sipping on root beer. Go figure. What am I trying to do? I'm trying to make that bigger. And I need to put myself in the corner. I'll move things around, so now I'm having a hard time seeing some of the stuff. There I am. I'm in the corner. So let's take it off of pause. And it says jury question number 3. I don't remember what number 2 was. Unless it was, can we...
You are unmuted.
Thank you. See the court session.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right. So, counsel, you're aware of our note from the jury. Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tuey-Rodrigues instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right, thank you. Ms. Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock, and they have nowhere to turn. So our position is the jury should be read the Tuey-Rodrigues model instruction and go from there.
Okay. All right, so you all know that it is within my discretion. I decide. So a case that has been, it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
I will tell you what the one thing that they're talking about is when we get done here. The Tuey-Rodrigues that they referred to. Tuey-Rodrigues instruction. I will, only because I just saw it. And I'll share that with you when we're done here. Oh, I don't understand what the hang-up is. I don't know if they understand. I don't know if somebody's thinking that the defense had to prove who did it. I don't know if somebody's mistaken in that respect. I don't know if they fully realize that the question is there reasonable doubt with any of the evidence that was brought forward? Is there reasonable doubt? The Commonwealth is the one who has to prove things. And I don't know if somebody is getting that all mixed up with, well, the defense didn't prove anything. Actually, the defense did, if you were paying attention. They proved that this body and this body did not hit.
Back in session, you may be seated.
Right. So, jurors, I'm in receipt of your note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by your foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations. All right? So I'm sending you back out.
All rise for the court, please. Follow me, please.
And I am surprised that the Commonwealth is pushing for them to continue. But maybe it's a matter of if they don't encourage them to continue, it could be a matter of appeal. That they didn't give the jury reasonable length of deliberation.
Thank you. Be seated. Court is still in session.
All right, so the note has been marked for identification, and we'll see you all either at 3:30 or when you get a phone call.
Court, all rise.
Triple V. Thank you.
Okay,
You are muted.
well, as I should be. We're going to go ahead and scan through this. I got home not long ago, so I wasn't here at the beginning. So I'm reviewing all of this with you. They play music now. How's that? I don't know what time that was that she just did it. Was that 12? Yeah, it was before lunch. The jurors' lunch has not arrived yet, and they will decide whether to deliberate through lunch as they have done for the past 3 days. As of now, they are deliberating. And I guess she sends notes back. You'll hear that in a minute or 2 or 3 or 4. You know, are you guys going to continue? We're almost at the end here. And hopefully I'm not skipping anything. There's, again, a lot of speculation going on. They're going to be on the record soon, which is like 15 minutes before this. Clock was paused at 20 hours, 21 minutes, and then later it was a little bit longer than that. Well, I found a nifty new thing. You can use J and L to either rewind 10 seconds or go forward 10 seconds. So I'll be trying that when I'm trying to zero in on something. I have to just keep trying it here. Because I saw the judge. Where was she? There she is. I didn't do that.
Thank you, BC, sir. Court session.
All right, so I sent the note in at 3:30 like I've done each day, asking if they want to go home or continue. They indicated that they want to continue until 4:15. So we will continue until 4:15.
Which
Madam Court Reporter,
45
thank you.
minutes more, because it was
Okay.
around 3:30.
All right, so I'll see you at 4:15.
Court, all rise. Court stands recess.
This is, I will be happy when we're on the other side of all this and we're able to get why. Somebody wants it spelled out to them. And the problem is, if there's reasonable doubt, it's not going to be spelled out to you. Come on. Thank you. Thank you. I'm fast forwarding 10 seconds at a time because I'm like right there. Right there. Right there. At least I thought it was. I really thought they would have come to a conclusion.
All right. So jurors, we all know how hard you've been working. It's been a long day. We're going to let you go home. We'll see you Monday morning at 9 o'clock. To the extent that you can, please just not think about this case this weekend. Clear your heads. We'll start fresh on Monday. So please follow those instructions. Do not discuss this case with anyone. Don't do any independent research and investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it. We'll see you later. Thank you.
All rise to the court, please.
Did I miss it?
Jurors, follow me.
There was a discussion. How did I miss it? Are they going to do it now? How did I miss it?
Thank you. Be seated. Court is still in session.
All right. We'll see you Monday morning. Thank you.
Thank you, Your Honor.
I missed it. I've got to find it because it's important. Because she asked both. Wow. It's hiding.
You until 4:15. Madam Court Reporter, thank you.
That wasn't it. Did I already
Okay.
play it?
All right. So I'll see you at 4:15.
Court will rise, court stands recessed.
So
She heard arguments from both sides.
Thank you, VC, sir. Court session.
all right. So I sent the note in at 3:30 like I've done each.
No.
Thank you, VC, sir. Court session.
All right. So I sent the note in at 3:30 like I've done each day, asking if they want to go home or continue. They indicated that they want to continue until 4:15. So we will continue until 4:15. Madam Court Reporter, thank you.
Did I already play that? I
Okay.
guess I already played that. I'm
All
sorry.
right. So I'll see you at 4:15.
Court will rise.
If
court
I
stands
didn't,
recessed.
then I get to redo this whole thing.
You-
Are muted. Yeah, because I said I was surprised that the Commonwealth wanted them to continue. All right. Let me see if I can find. Oh, here it is. Let me see if this is it. I know you can't see it just yet, but I want to make sure I've got the right thing. Yes. All right. Let me share this. And I can't share it until I get rid of this one. Now, I want to share this one. Let's see, how do I make it bigger? We need to be bigger. Nope, not that. We're going here. Up here. Let's make it bigger. All right, let's see how that looks. No, I want to make it bigger. That's better. That's even better. So I'm going to put me down there. I'm going to go back in the corner. That's where I work the best. I'm going to make this even bigger. All right. How does that look? How do I get rid of all this stuff? Anyway, Andrea Burkhart is an excellent lawyer. How do I get rid of this? She says, okay, I've been sorting through Massachusetts law to get a sense of what happened this morning, and this thread will address what I found. Bottom line, so far, it's unlikely that there has been any appealable error. When a jury can't reach a unanimous verdict, courts can instruct them to continue their deliberations so long as the instruction to do so does not coerce a verdict. This rule derives from U.S. Supreme Court precedent in Allen v. U.S. I heard a lot of Allen v. U.S., I think. Never mind. I thought I heard a lot of that with Depp v. Heard, but I could be wrong. Andrea Burkhart on Twitter is at aburkhartlaw. She also has a YouTube page that you can follow her there. That's where I'm most familiar with her. You can read this. This is what she's referring to. Under Massachusetts law, there is a form instruction called, you heard this being mentioned, a Tuey-Rodrigues instruction. It's named after two cases that generated it. To be given if, after due and thorough deliberation, is that what I wrote down? No. Yes, due and thorough deliberation, the jury is deadlocked. You can read that instruction here. Excuse me. Massachusetts law also has an interesting quirk that the jury cannot be sent back a second time to deliberate after they have deadlocked following due and thorough deliberation. This rule is statutory from all those letters and numbers. Note, however, that these rules only apply if there has been due and thorough deliberation. This is why Judge Bev specifically found that there has not been due and thorough deliberation at this point. And Lally agreed. Under Massachusetts law, the determination of whether deliberations have been due and thorough is discretionary with the court, meaning it's only overturned if it is patently unreasonable. The bar there is very high. She quotes more things. So this means that Judge Bev has not yet initiated the last chance sequence that requires the Tuey-Rodrigues instruction, or limits her ability to send the jury back again to continue deliberations if they repeat that they are deadlocked. Notably, however, the judge can still run afoul of the restriction against coercing a jury verdict by refusing to release them in a reasonable time or by placing pressure on the minority to abandon their convictions. Coerciveness is a totality of the circumstances test. At this point in time, there does not seem to be a viable appeal argument that what has been done is error. However, the longer the jury is out without making progress, the less likely it is that the judge could order them to continue without creating a coercive environment. So I don't know if technically she has to read this law, this Tuey-Rodrigues instruction, and then they have, is that the last strike, or is that from then on? What I'm trying to say is, do they have to get a warning, and then when they do it the second time, they won't be sent back again? So I'm not clear on that. I'd have to read this a couple more times. But that explains a little bit. I didn't know they were going to mention the Tuey-Rodrigues instruction. But even though we are anxious and we feel they've had plenty of time, we're not in there. We don't know who's arguing, who's complaining, we don't know what's going on back there. I think they're just plain tired and they don't want to deal with it anymore. And this person is giving them a hard time, or persons, and they just don't have it in them to continue to try to get them to understand what they're referring to. So I don't know. Maybe being gone for a weekend will help them clear the cobwebs, come back fresh Monday, and go, hey, look, I was thinking about this. And how about da 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 da? Or did you think of it this way? Da 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 da. We definitely don't want a guilty verdict. Second best, if it's not guilty, second best would be deadlock, a hung jury. The problem with that is it could be tried again. Or, I think, or all the charges could be dropped because Commonwealth doesn't want to do this again either. I don't know. I'm not positive. I don't know this stuff. I'm just a snarky juror. I don't know all this legalese. I got a text about something, so let me take a look in case it refers to this. Yeah. See, I'm disappointed. I'm disappointed. Now we know what's taking what we feel is so long. But as yeah, I've been getting these, your Google verification code is, I didn't request one. It's some kind of spam. And so I've been ignoring it, but maybe I shouldn't. So I just responded, did not request. So I don't know if somebody's trying to use my stuff or what. Anyway, woe is me. At least we know what the problem is, why they haven't come back with a definite verdict yet. But it's only been 20 hours of deliberations. And as the judge said, one day it was only 2 hours. The next day it was, again, less than a full day because there was a doctor's appointment. Then the next one, there's been these allowances, and they're exhausted because they're trying to get this other person or persons to comprehend what they're trying to tell them. Now, who knows? Maybe the holdouts are the ones that are voting not guilty, and the majority is voting for guilt. I don't think so. That doesn't sound reasonable to me. But we're on the outside looking in. I still have that fear that someone's applying pressure and saying, don't you dare. Don't you dare. We know where your kids are. We know where you go to work. We know where you go to the grocery store. Intimidation. And when the Alberts and the McCabe's were sitting there across from the jury and closing arguments, that was intimidation. That's why they were there. That's the only reason they were there. I mean, you go from the debacle on the stage last night and knowing what horrible things are happening to our country. You're hoping that, okay, got to get this right. Good versus evil. It's aggravating. It's aggravating. It's disheartening. So everybody needs to take a step back, take a deep breath, clear your mind. I'm going to go play with the lawnmower because it needs done. My middle son would prefer to be doing it, but he's having problems with his shoulder. So there's days he can't. And I understand that. So I do what I can when I can. But I'll go do that and clear my head and read a book, watch some other YouTube, watch some TV. I haven't watched my one soap in 2 weeks. And I don't know how long they hold it in reserve for me to catch up. And then I don't know if there's new seasons of any of the, what's it called? There's one, the USA version, the UK version, the New Zealand version, and Australian version. What is it I'm thinking of? You'll figure it out. It's not suicide. You're either a faithful or traitor. That's what it's called, traitor. Those get me riled up too because there's some skullduggery going on those shows. Anyway, try to block it out of your mind for the weekend. Take a deep breath, take a step back, do something fun, go to the movies, go to the pool, go mow your yard, read a book. Send up a few prayers that justice is done. Ask for God's blessings on everyone involved, everyone, and let His will be done. Amen. So until the next time, you know what I'm going to say. Take care and God bless.